starting with Justice Sotomayor's dissenting opinion, and then it references back to quite a bit of the original case, and we'll just read that as it goes through. So this is the Trump v. United States case and the dissenting opinions from them, starting with Justice Sotomayor. Let's do one last quick check for the audio. Okay. It's as good as it's going to get for now. Working on audio, and it'll be better soon, but for right now, that's as good as it's going to get, and I apologize. I really do. Justice Sotomayor, with whom Justice Kagan and Justice Jackson joined dissenting. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Relying on little more than its own misguided wisdom about the need for, quote, bold and unhesitating action, end quote, by the president, the court gives former President Trump all the immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. Disagrees because it goes against the Constitution. It's crazy. People have values and principles. The indictment paints a stark portrait of a president desperate to stay in power. In weeks leading up to January 6, 2021, then President Trump allegedly, quote, spread lies that there had been outcome determinative fraud in the election and that he had actually won, end quote, despite being, quote, repeatedly notified, end quote, by his closest advisors that, quote, that his claims were untrue, end quote. When dozens of courts swiftly rejected these claims, Trump allegedly, quote, pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately caused the ascertainment of and voting by illegitimate electors, end quote, in his favor. It is alleged that he went so far as to threaten one state election official with criminal prosecution if the official did not, quote, find 11,780 votes, end quote. Trump needed to change the election result in that state. When state officials repeatedly declined to act outside their legal authority and alter their state election processes, Trump and his co-conspirators purportedly developed a plan to disrupt and displace the legitimate election certification process by organizing fraudulent slates of electors. In case you haven't heard this before. As the date of the certification proceeding neared, Trump allegedly also sought to, quote, use the power and authority of the Justice Department, end quote, to bolster his knowingly false claims of election fraud by initiating, quote, sham election crime investigations, end quote, and sending official letters, quote, falsely claiming that the Justice Department had identified significant concerns that may have impacted the election outcome, end quote, while, quote, falsely presenting the fraudulent electors as a valid alternative to the legitimate electors, end quote. When the department refused to do as he asked, Trump turned to the vice president. Initially, he sought to persuade the vice president, quote, to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results, end quote. When persuasion failed, he purportedly, quote, attempted to use a crowd of supporters that he had gathered in Washington, D.C. to pressure the vice president to fraudulently alter the election results, end quote. Speaking to that crowd on January 6, Trump, quote, falsely claimed that, based on fraud, the vice president could alter the outcome of the election results, end quote. When this crowd then, quote, violently attacked the Capitol and halted the proceeding, end quote, Trump allegedly delayed in taking any step to rein in the chaos he had unleashed. Instead, in a last desperate ploy to hold on to power, he allegedly, quote, attempted to exploit the violence and the chaos at the Capitol, end quote, by pressuring lawmakers to delay the certification of the election and ultimately declare him the winner. That is the backdrop against which this case comes to the court. The court now confronts a question it has never had to answer in the nation's history: whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should, and so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The majority makes three moves that, in effect, completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of, quote, core constitutional powers, end quote. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all, quote, official acts, end quote. Whether described as presumptive or absolute, under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad, quote, official acts, end quote, immunity is inconsistent with text, history, and established understandings of the president's role. Moreover, it is deeply wrong, even on its own functionalist terms. Next, the majority's, quote, core, end quote, immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary holding is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency, and for our democracy. So it's just referencing all the parts that she's pulling that from. Those are her statements, and then she expands on them below. Moving on. The main takeaway of today's decision is that all of a president's official acts defined without regard to motive or intent are entitled to immunity that is, quote, at least presumptive, end quote, and quite possibly, quote, absolute, end quote. Whenever the president wields the enormous power of his office, the majority says the criminal law, at least presumptively, cannot touch him. This official acts immunity has, quote, no firm grounding in constitutional text, history, or precedent, end quote. That's Dawes v. Jackson, Women's Health Organization, 2022. Indeed, those, quote, standard grounds for constitutional decision-making, end quote, all point in the opposite direction. No matter how you look at it, the majority's official acts immunity is utterly indefensible. The majority calls for a, quote, careful assessment of the scope of presidential power under the Constitution, end quote. For the majority, that, quote, careful assessment, end quote, does not involve the Constitution's text. I would start there. The Constitution's text contains no provision for immunity from criminal prosecution for former presidents. Of course, quote, the silence of the Constitution on the score is not dispositive, end quote, United States v. Nixon, 1974, insofar as the majority rails against the notion that a, quote, specific textual basis, end quote, is required. It is attacking an argument that has not been made here. The omission in the text of the Constitution is worth noting, however, for at least three reasons. First, the framers clearly knew how to provide for immunity from prosecution. They did provide a narrow immunity for legislators in the speech and debate clause, basically you can't stop them. It says it here, quote, senators and representatives shall, in all cases except treason, felony, and breach of peace, be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place, end quote. They did not extend the same or similar immunity to presidents. Second, quote, some state constitutions at the time of the framing specifically provided, and another quote, express criminal immunities, end that quote, to sitting governors, end all quotes. Brief for Scholars Constitutional Law, number 4, looks like, quoting Prakash, prosecuting, 2021, bunch of other stuff. Moving on. The framers chose not to include similar language in the Constitution to immunize the president. If the framers, quote, had wanted to create some constitutional privilege to shield the president from criminal indictment, end quote, they could have done so. The memorandum from this place about the indictability of the president, they did not. So they just did not include this stuff. They could have, and they did for other things, but they chose not to do so for this. Third, insofar as the Constitution does speak to this question, it actually contemplates some form of criminal liability for former presidents. The majority correctly rejects Trump's argument that a former president cannot be prosecuted unless he has been impeached by the House and convicted by the Senate for the same conduct. The majority ignores, however, that the impeachment judgment clause cuts against its own position. That clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate, quote, shall nevertheless be liable and subject to indictment, trial, judgment, punishment according to the law, and punishment according to the law, end quote. Article 1, Section 3, Clause 7. That clause clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted in an impeachment judgment, including conduct such as, quote, bribery, end quote, Article 2, Section 4, which implicates official acts almost by definition. Aware of its lack of textual support, the majority points out that this court has, quote, recognized presidential immunities and privileges, in another quote, rooted in the constitutional tradition of the separation of powers and supported by our history, end all quotes. That is true as far as it goes. Nothing in our history, however, supports the majority's entirely novel immunity from criminal prosecution for official acts. The historical evidence that exists on presidential immunity for criminal prosecution cuts decisively against it. For instance, Alexander Hamilton wrote that former presidents would be, quote, liable to prosecution and punishment in the ordinary course of law, end quote. The Federalist number 69. For Hamilton, that was an important distinction between, quote, the King of Great Britain, end quote, who was, quote, sacred and inviolable, end quote, and the, quote, President of the United States, end quote, who, quote, would be amenable to personal punishment and disgrace, end quote. In contrast to the king, the president should be subject to, quote, personal responsibility, end quote, for his actions. Quote, standing upon no better ground than a governor of New York and upon worse ground than the governors of Maryland and Delaware, end quote, whose state constitutions gave them some immunity. At the Constitutional Convention, James Madison, who was aware that some state constitutions provided governors immunity, proposed that the convention, quote, consider what privileges ought to be allowed to the executive, end quote. There is no record of any such discussion. Delegate Charles Pinckney later explained that, quote, the convention which formed the Constitution well knew, end quote, that, quote, no subject had been more abused than privilege, end quote, and so it, quote, determined to limit privilege to what was necessary and no more, end quote. Quote, no privilege was intended for the executive, end quote. Pretty clear how they felt about it. Other commentators around the time of the founding observed that the federal officials had no immunity from prosecution, drawing no exception for the president. James Wilson recognized that federal officials who use their official powers to commit crimes, quote, may be tried by their country, and if their criminality is established, the law will punish. A grand jury may present, a petty jury may convict, and the judges will pronounce the punishment, end quote. A few decades later, Justice Story evinced the same understanding. He explained that when a federal official commits a crime, quote, it is indispensable that provision should be made that the common tribunals of justice should be at liberty to entertain jurisdiction of the offense for the purpose of inflicting the common punishment applicable to unofficial offenders, end quote. Without a criminal trial, he explained, quote, the grossest official offenders might escape without any substantial punishment, even for crimes which would subject their fellow citizens to capital punishment, end quote. This historical evidence reinforces that, from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. The majority fails to recognize or grapple with the lack of historical evidence for its new immunity. With nothing on its side on the ledger, the most the majority can do is claim that the historical evidence is a wash. It claims that the court previously has described the, quote, relevant historical evidence on the question of presidential immunity, end quote, as, quote, fragmentary, end quote, and not worthy of consideration. Yet the court has described only the evidence regarding, quote, the president's immunity from damages liability, end quote, as, quote, fragmentary, end quote. Moreover, far from dismissing that evidence as irrelevant, the Fitzgerald court was careful to note that, quote, the best historical evidence clearly supported, end quote, the immunity from damages liability that is recognized, and it relied in part on that historical evidence to overcome the lack of any contextual basis for its immunity. The majority ignores this reliance. It seems history matters to this court only when it's convenient. Our country's history also points to an established understanding shared by both presidents and the Justice Department that former presidents are answerable to the criminal law for their official acts. Schiaffolo v. Washington, 2020, quote, long settled and established practice, and that, quote, may have, and another quote, great weight in a proper interpretation of constitutional provisions, end all quotes. Consider Watergate, for example. After the Watergate tapes revealed President Nixon's misuse of official power to obstruct the Federal Bureau of Investigation's investigation of the Watergate burglary, President Ford pardoned Nixon. Both Ford's pardon and Nixon's acceptance of the pardon necessarily, quote, rested on the understanding that the former president faced potential criminal liability, end quote. That was from a brief from 1975, saying granting former President Nixon a, quote, full, free, and absolute pardon for all offenses against the United States which he has committed or may have committed or taken part in during, end quote, his presidency. The Nixon statement, 1974, accepting, quote, full and absolute pardon for any charges which might be brought against me for actions taken during the time I was president of the United States, end quote. So very clearly acknowledging that everybody understood this. Subsequent special counsel and independent counsel investigations have also operated on the assumption that the government can criminally prosecute former presidents for their official acts, where they violate the criminal law. See Final Independent Counsel on Iran-Contra, 1993, quote, because a president, and certainly a past president, is subject to prosecution, the conduct of President Reagan in the Iran-Contra matter was reviewed by the Independent Counsel against the applicable statutes. It was concluded that his conduct fell well short of criminality which could be successfully prosecuted. So they have made these considerations before, but in those cases, you have to remember, if you're wondering why are they always going after Trump? Why is it always him? Why do they do it? Because he breaks the law more than these other people. They look at these things and then they say, oh, these aren't crimes. And then they look at Trump's and then they say, oh, these are crimes. If it feels like he's being targeted, it's because he's committing the crimes. That's the problem. If you're wondering, in case you're wondering, in case anybody's listening that ever was curious enough to wonder why it feels like you're targeted. Indeed, Trump's own lawyers during his second impeachment trial assured senators that declining to impeach Trump for his conduct related to January 6th would not leave him, quote, in any way above the law, end quote. His own lawyers said that. They insisted that a former president, quote, is like any other citizen and can be tried in a court of law, end quote. Trump's impeachment counsel stating that, quote, no former office holder is immune, end quote, from the judicial process, quote, for investigation, prosecution, and punishment, end quote. Trump's impeachment counsel stating, quote, if my colleagues on this side of the chamber actually think that President Trump committed a criminal offense after he is out of office, you go and arrest him, end quote. Now that Trump is facing criminal charges for those acts, though, the tune has changed. Being treated, quote, like any other citizen, end quote, no longer seems so appealing. In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers, until now. Settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them. Setting aside this evidence, the majority announces that former presidents are, quote, absolutely, end quote, or, quote, at least presumptively, end quote, immune from criminal prosecution for all of their official acts. The majority purports to keep us in suspense as to whether this immunity is absolute or presumptive, but it quickly gives up the game. It explains that, quote, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no, quote, in another quote, dangers of intrusion on the authority and functions of the executive branch, end all quotes. No dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be, quote, justified by an overriding need to promote objectives within the constitutional authority of Congress, end quote. Nixon v. Administrator of General Services, 1977. Other intrusions may be justified by the, quote, primary constitutional duty of the judicial branch to do justice in criminal prosecutions, end quote, United States v. Nixon, 1974. According to the majority, however, any incursion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to, quote, whether official acts immunity must be absolute, end quote, or whether instead, quote, presumptive immunity is sufficient, end quote, hardly matters. Maybe some future opinion of this court will decide that presumptive immunity is, quote, sufficient, end quote, and replace the majority's ironclad presumption with one that makes the difference between presumptive and absolute immunity meaningful. Today's court, however, has replaced a presumption of equality before the law with a presumption that the president is above the law for all of his official acts. Quick on the heels of announcing this astonishingly broad official acts immunity, the majority assures us that a former president can still be prosecuted for, quote, unofficial acts, end quote. Of course he can. No one has questioned the ability to prosecute a former president for unofficial, otherwise known as private, acts. Even Trump did not claim immunity for such acts, and, as the majority acknowledges, such an immunity would be impossible to square with the Clinton v. Jones 1997 opinion. This unremarkable proposition is no real limit on today's decision. It does not hide the majority's embrace of the most far-reaching view of presidential immunity on offer, In fact, the majority's dividing line between, quote, official, end quote, and, quote, unofficial, end quote, conduct narrows the conduct considered, quote, unofficial, end quote, almost to a nullity. So I'm going to read that without the quotes so that we get it. In fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is, quote, not manifestly or palpably beyond his authority, end quote, he is taking official action. Holy shit. So crazy. I probably got this on the first go round, but we're going to get it again, and I will sort through it on the backside. Because that's a real good one, real short one. It then goes a step further, quote, in dividing official from unofficial conduct, courts may not inquire into the president's motives, end quote. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it is quite another to make it irrelevant to questions regarding criminal liability. Under that rule, any use of official power for any purpose, even the most corrupt purpose, indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed, quote, unofficial, end quote, is destined to be vanishingly small. Ultimately, the majority pays lip service to the idea that, quote, the president charged with enforcing federal criminal laws is not above them, end quote. But it then proceeds to place former presidents beyond the reach of federal criminal laws for any abuse of official power. So how does the majority get to its rule? With text, history, and established understanding all weighing against it, the majority claims just one arrow in its quiver, the balancing test in Nixon v. Fitzgerald, 1983. Yet, even that test cuts against it. So, because they have no evidence, no backing, no real thing, this is their one real argument, and then she's about to tear it down. Yet, even that test cuts against it. The majority concludes that the official act's immunity, quote, is required to safeguard the independence and effective functioning of the executive branch, end quote, by rejecting that branch's own protestations that such immunity is not at all required and would in fact be harmful. In doing so, it decontextualizes Fitzgerald's language, ignores important qualifications, and reaches a result that the Fitzgerald court would never have countenanced. In Fitzgerald, Plaintiff A, Ernest Fitzgerald, sued then former President Nixon for money damages. He claimed that, while in office, Nixon had been involved in unlawfully firing him from his government job. The question for the court was whether a former president had immunity for such a civil suit. The court explained that it was, quote, settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the president of the United States, end quote. To determine whether a particular type of suit against a president or former president could be heard, a court, quote, must balance the constitutional weight of the interests to be served against the dangers of intrusion on the authority and functions of the executive branch, end quote. The court explained that, quote, when judicial action is needed to serve broad public interest, as when the court acts not in derogation of the separation of powers, but to maintain their proper balance or to vindicate the public interest in an ongoing criminal investigation, the exercise of jurisdiction has been held warranted, end quote. On the facts before it, the court concluded that a, quote, merely private suit for damages based on a president's official acts, end quote, did not serve those interests. The court reasoned that the, quote, visibility of the president's office and the effect of his actions on countless people, end quote, made him an easy target for civil suits that, quote, frequently could distract him from his public duties, end quote. The public interest in such private civil suits, the court concluded, was comparatively weak. Quote, there is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions, end quote. Therefore, the court held that a former president was immune from such suits. In context of a federal criminal prosecution of a former president, however, the danger to the functioning of the executive branch is much reduced. Further, as every member of the Fitzgerald court acknowledged, the public interest in a criminal prosecution is far weightier. Applying the Fitzgerald balancing here should yield the opposite result. Instead, the majority elides any difference between civil and criminal immunity, granting Trump the same immunity from criminal prosecution that Nixon enjoyed from an unlawful termination suit. That is plainly wrong. The majority relies almost entirely on its view of the danger of intrusion on the executive branch to the exclusion of the other side of the balancing test. Its analysis rests on a questionable conception of the president as incapable of navigating the difficult decisions his job requires while staying within the bounds of the law. It also ignores the fact that he receives robust legal advice on the lawfulness of his actions. The majority says that the danger, quote, of intrusion on the authority and functions of the executive branch, end quote, posed by criminally prosecuting a former president for official conduct, quote, is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability. I don't know why I keep messing that up. So I'm going to do the quote from the beginning again. Quote, is akin to indeed greater than what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking, in another quote, bold and unhesitating action, end that quote, required of an independent executive, end all quotes. It is of course important that the president be able to, quote, deal fearlessly and impartially with, end quote, the duties of his office, end all quotes. If every action the president takes exposes him personally to vexatious private litigation, the possibility of hamstringing presidential decision-making is very real. Yet there are many facets of criminal liability which the majority discounts that make it less likely to chill presidential action than the threat of civil litigation. First, in terms of probability, the threat of criminal liability is much smaller. In Fitzgerald, the threat of vexatious civil litigation loomed large. The court observed that, given the, quote, visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for suits for civil damages, end quote. Although, quote, the effect of the president's actions on countless people, end single quote, could result in untold numbers of private plaintiffs suing for damages based on any number of presidential acts, end quote. In the civil context, the risk in the criminal context is, quote, only that a former president may face one federal prosecution in one jurisdiction for each criminal offense allegedly committed while in office, end quote. So it's limiting by its definition. Just the aggrieved parties are going to be smaller or less. The majority's bare assertion that the burden of exposure to federal criminal prosecution is more limiting to a president than the burden of exposure to civil suits does not make it true, and it is not persuasive. Second, federal criminal prosecutions require, quote, robust procedural safeguards, end quote, not found in civil suits. The criminal justice system has layers of protections that, quote, filter out insubstantial legal claims, end quote, whereas civil litigation lacks, quote, analogous checks, end quote. Cheney v. United States, 2004. To start, Justice Department policy requires scrupulous and impartial prosecution founded on both the facts and the law. The grand jury provides an additional check on felony prosecutions, acting as a, quote, buffer or referee between the government and the people, end quote, to ensure that the charges are well-founded. United States v. Williams, 1992, Harlow v. Fitzgerald, 1982. From Berger C.J. Dissenting. Quote, a criminal prosecution cannot be commenced absent careful consideration by a grand jury at the request of a prosecutor. The same check is not present with respect to the commencement of civil suits in which advocates are subject to no realistic accountability, end quote. If the prosecution makes it past the grand jury, then the former president still has all the protections our system provides to criminal defendants. If the former president has an argument that a particular statute is unconstitutional as applied to him, then he can move to dismiss the charges on that ground. Indeed, a former president is likely to have legal arguments that would be unavailable to the average criminal defendant. For example, he may be able to rely on a public authority exception for particular criminal laws, or an advice of the Attorney General defense. See oral arguments from 107, 108. It's a weird one. Nardone v. United States. Just reading through the footnote of these two really quick. So 3 and 4 that are here. So we'll refresh action. See Nardone v. United States explaining that public officers may be, quote, impliedly excluded from statutory language embracing all persons, end quote, if the reading of the statute to include such officers, quote, would work obvious absurdity as, for example, the application of a speed law to a policeman pursuing a criminal or the driver of a fire engine responding to an alarm, end quote. And then the other footnote, Trump did not raise those defenses in this case, and the immunity that the majority has created likely will obviate the need to raise them in future cases. Yet those defenses would have protected former presidents from unwarranted criminal prosecutions much more precisely than the blanket immunity the majority creates today. So the big thing with that to remember is they're giving this immunity, and all of this portion is saying that you didn't have to give this. You didn't have to go out of your way in order to do this, when all of these other checks that we have against prosecuting someone frivolously for criminal stuff, those are already in place. You don't have to change anything in order to do that. Those are already there. And this is them pleading with the other side of the court, hey, we have a good criminal system, and there are all these checks, and he even has some defenses that aren't available to other people. You or me, we may not have the same things that he has, like the ability to say my attorney general told me to do so, like the ability to kind of pass the buck there. We don't have that. We are responsible for our own actions. He has extra defenses already. Why do you have to give this sweeping immunity? And unfortunately, they did. They went ahead and gave it. So now we get to see the fallout. If the case nonetheless makes it to trial, the government will bear the burden of proving every element of the alleged crime beyond a reasonable doubt to a unanimous jury of the former president's fellow citizens. If the government manages to overcome even that significant hurdle, then the former president can appeal his conviction, and the appellate review of his claims will be, quote, particularly meticulous, end quote. He can ultimately seek this court's review, and if past practice, including in this case, is any indication, he will receive it. In light of these, it sounds like she's desperately saying, like, hey, don't do this sweeping immunity for presidents going into the future just because of this one guy. And you don't even have to do it, because if he were to get charged with a crime and it were to make it to us, we know you'd give it away. We know you wouldn't choose to actually hold him accountable for his crimes. We know you like this guy so much, you'll throw away everything for it. Don't throw away everything into the future. They're saying, okay, fine. The wording of this at least comes to me like, hey, we know you're going to give him immunity. We know you're going to give away the game, but don't do it forever. Don't do it into the future. Don't make this immunity shit part of the record. Please, 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 please. This is her bargaining. This is her stages of acceptance, or grief. This is her denial stage, or the first part was her denial stage. Now's her bargaining stage. She's saying in these parts, please don't do this. We know you let him get off with any crime anyway. We know Trump is never getting anything, and that's fine. It's not on the table. But please don't do this sweeping immunity. It will destroy us. Moving on to the next part of Justice Sotomayor's dissenting opinion. In light of these considerable protections, the majority's fear that, quote, bare allegations of malice, end quote, would expose former presidents to trial and conviction is unfounded. Bare allegations of malice would not make it out of the starting gate. Although a private civil action may be brought based on little more than, quote, intense feelings, end quote, a federal criminal prosecution is made of firmer stuff. Certainly, there has been, on occasion, great feelings of animosity between incoming and outgoing presidents over the course of our country's history. Yet it took allegations as grave as those at the center of this case to have the first federal criminal prosecution of a former president. That restraint is telling. So this is your moment. These are the Justice Sotomayor saying, if it feels like, oh, we never did this before, it's because no one ever broke the fucking law like this. You don't get to say, oh, well, it's my guy and you're going after him, it's lawfare. No, you choose to support someone who breaks more laws than anybody else, so accept that he just breaks more laws than anybody else. And accept that they're going to try, or at least they tried, that I don't know if they'll succeed, but they will try to hold him to account for that. If it feels like you're being unfairly targeted, it's because you break the law more. Your side is breaking the law more. The person that you support is breaking the law more. So yes, the law is going to deal with him more. Third, because of long-standing interpretations by the executive branch Every sitting president has so far believed himself under the threat of criminal liability after his term in office and nevertheless boldly fulfilled the duties of his office. The majority insists that the threat of criminal sanctions is, quote, more likely to distort presidential decision-making than the potential payment of civil damages, end quote. If that is right, then that distortion has been shaping presidential decision-making since the earliest days of the Republic. Although it makes sense to avoid, quote, diversion of the president's attention during the decision-making process, end quote, with, quote, needless worry, end quote, one wonders why requiring some small amount of his attention or his legal advisor's attention to go towards complying with federal criminal law is such a great burden. If the president follows the law that he must, quote, take care, end quote, to execute, he has not been rendered, quote, unduly cautious, end quote. Oh, unduly cautious. We'll reread that again. If the president follows the law that he must take care to execute, he has not been rendered unduly cautious. Some amount of caution is necessary after all. It is a far greater danger if the president feels empowered to violate federal criminal law, buoyed by the knowledge of future immunity. I am deeply troubled by the idea inherent in the majority's opinion that our nation loses something valuable when the president is forced to operate within the confines of federal criminal law. So what exactly is the majority worried about deterring when it expresses great concern for the, quote, deterrent, end quote, effect that, quote, the threat of trial, judgment, and imprisonment, end quote, would pose? It cannot possibly be the deterrence of acts that are truly criminal, nor does it make sense for the majority to wring its hands over the possibility that presidents might stop and think carefully before taking action that borders on criminal. Instead, the majority's main concern could be that presidents will be deterred from taking action necessary and lawful action by the fear that their successors might pin them with a baseless criminal prosecution. A prosecution that would almost certainly be doomed to fail if it even made it out of the starting gate. The court should not have so little faith in this nation's presidents. As this court has said before in the context of criminal proceedings, quote, the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice, end quote. The concern that countless and baseless civil suits would hamper the executive may have been justified in Fitzgerald, but a well-founded federal criminal prosecution poses no comparable danger to the functioning of the executive branch. At the same time, the public interest in a federal criminal prosecution of a former president is vastly greater than the public interest in a private individual's civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in quote, in criminal prosecutions, end quote, than in, quote, actions for civil damages, end quote. Chief Justice Berger's concurrence accordingly emphasized that the majority's immunity was, quote, limited to civil damages claims, end quote, rather than, quote, criminal prosecution. It literally says it right there. It says it right there, end quote. But my goodness, it says it right there. This is for civil, not for criminal. Insane. The 4 dissenting justices agreed that a, quote, contention that the president is immune from from criminal prosecution in the courts, end quote, if ever made, would not, quote, be credible, end quote. My goodness. So even the justices that disagreed with this ruling, they came out and said, quote, contention that the president is immune from criminal prosecution in the courts, end quote, if ever made, would not, quote, be credible, end quote. So these are the people that voted against. So this was doing some, establishing civil immunity, and then they dissented against it, but they also admit that there wouldn't be, it'll be worth looking into that court case to see, but my goodness, everyone agreed that this had nothing to do with criminal immunity and shouldn't be extended in the future. At least that's what it looks like to me. The public's interest in prosecution is transparent. A federal prosecutor herself acts on behalf of the United States. Even the majority acknowledges that the, quote, federal criminal laws seek to redress, another quote, a wrong to the public, end that quote, as a whole, not just, another quote, a wrong to the individual, end all quotes. Such that there is, quote, a compelling, quote, public interest in fair and effective law enforcement, end all quotes. Indeed, quote, our historic commitment to the rule of law, end quote, is, quote, nowhere more profoundly manifest than in our view that, quote, guilt shall not be escaped or innocence suffer, end all quotes. Nixon from Burger v. United States, 1935. The public interest in criminal prosecution is particularly strong with regard to officials who are granted some degree of civil immunity because of their duties. It is in those cases where the public can see that officials exercising power under public trust remain on equal footing with their fellow citizens under the criminal law. O'Shea v. Littleton, 1974, quote, we have never held that the performance of the duties of judicial, legislative, or executive officers requires or contemplates the immunization of otherwise criminal deprivations of constitutional rights, end quote. Dennis v. Sparks, 1980, quote, judicial immunity was not designed to insulate the judiciary from all aspects of public accountability. Judges are immune from 1983 damages actions, but they are subject to criminal prosecutions, as are other civilians, end quote. Imler v. Packman, 1976. Hey, David Packman, what up? Quote, we emphasize that the civil immunity of prosecutors does not leave the public powerless to deter misconduct or to punish that which occurs. This court has never suggested that the policy considerations which compel civil immunity for certain governmental officials also place them beyond the reach of the criminal law. Even judges cloaked with absolute civil immunity for centuries could be punished criminally, end quote. The public interest in federal criminal prosecution of a former president alleged to have used the powers of his office to commit crimes may be greater still. Quote, the president represents all the voters in the nation, end quote, and his powers are given by the people under our Constitution. When presidents use the powers of their office for personal gain or as part of a criminal scheme, every person in the country has an interest in the criminal prosecution. The majority overlooks that paramount interest entirely. Finally, the question of federal criminal immunity for a former president, quote, involves a countervailing Article 2 consideration absent in Fitzgerald, end quote. Recognizing such an immunity, quote, would frustrate the executive branch's enforcement of the criminal law, end quote. The president is, of course, entrusted with, quote, supervisory and policy responsibilities of utmost discretion and sensitivity, end quote. One of the most important is, quote, enforcement of federal law, end quote, as, quote, it is the president who is charged constitutionally to, quote, take care that laws be faithfully executed, end all quotes. The majority seems to think that allowing former presidents to escape accountability for breaking the law while disabling the current executive from prosecuting such violations somehow respects the independence of the executive. It does not. Rather, it diminishes that independence, exalting occupants of the office over the office itself. There is a twisted irony in saying, as the majority does, that the person charged with, quote, taking care that the laws be faithfully executed, end quote, can break them with impunity. In this case before us, the public interest and countervailing interest, In the case before us, the public interest and countervailing Article 2 interest are particularly stark. The public interest in this criminal prosecution implicates both, quote, the executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, end quote, as well as, quote, the voters' interest in democratically selecting their president, end quote. It also, of course, implicates the Congress's own interest in regulating conduct through the criminal law. Yet, the majority believes that a president's anxiety over prosecution overrides the public's interest in accountability and negates the interest of the other branches in carrying out their constitutionally assigned functions. It is, in fact, the majority's position that, quote, boils down to ignoring the Constitution's separation of powers, end quote. Finally, in an attempt to put some distance between its official acts immunity and Trump's requested immunity, the majority insists that, quote, Trump asserts a far broader immunity than the limited one the majority has recognized, end quote. If anything, the opposite is true. The only part of Trump's immunity argument that the majority rejects is the idea that, quote, the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution, end quote. That argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment clause argument is the idea that a former president who was impeached in the House and convicted in the Senate for crimes involving his official acts could then be prosecuted in court for those acts. See brief Petitioner 22, quote, the founders thus adopted a carefully balanced approach that permits the criminal prosecution of a former president for his official acts, but only if that president is first impeached by the House and convicted by the Senate, end quote. By extinguishing that path to overcoming immunity, however nonsensical it might be, the majority arrives at an official acts immunity even more expansive than the one Trump argued for. On the majority's view, but not Trump's, a former president whose abuse of power was so egregious and so offensive even to members of his own party that he was impeached in the House and convicted in the Senate still would be entitled to, quote, at least presumptive, end quote, criminal immunity for those acts. Separate from its official acts immunity, the majority recognizes absolute immunity for, quote, conduct within the president's exclusive sphere of constitutional authority, end quote. Feel free to skip over those pages of the majority's opinion. With broad official acts immunity covering the field, this ostensibly narrower immunity serves little purpose. In any event, this case simply does not turn on conduct within the president's, quote, exclusive sphere of constitutional authority, end quote. And the majority's attempt to apply a core immunity of its own making expands the concept of, quote, core constitutional powers, end quote, beyond any recognizable bounds. The idea of a narrow core immunity might have some intuitive appeal in a case that actually presented the issue. If the president's power is, quote, conclusive and preclusive, end quote, on a given subject, then Congress should not be able to, quote, act on the subject, end quote. In his Youngstown concurrence, Justice Robert Jackson posited that the president's, quote, power of removal in executive agencies, end quote, seemed to fall within this narrow category. Other decisions of this court indicate that the pardon power also falls in this category. See United States v. Klein, 1872, quote, to the executive alone is entrusted the power of the pardon, and it is granted without limit, end quote. As does the power to recognize foreign countries. See, I don't know that name. Zivotofsky v. Kerry, 2015, holding that president has, quote, exclusive power to control recognition determinations, end quote. In this case, however, the question whether a former president enjoys a narrow immunity for the, quote, exercise of his core constitutional powers, end quote, has never been at issue, and for good reason. Trump was not criminally indicted for taking actions that the Constitution places in the unassailable core of the executive power. He was not charged, for example, with illegally wielding the presidency's pardon power or veto power or appointment power or even removal power. Instead, Trump was charged with a conspiracy to commit fraud to subvert the presidential election. It is true that the detailed indictment in this case alleges that Trump threatened to remove an acting attorney general who would not carry out his scheme. Yet it is equally clear that the government does not seek to, quote, impose criminal liability on the president for exercising or talking about exercising the appointment or removal power, end quote. If that were the majority's concern, it could simply have said that the government cannot charge a president's threatened use of the removal power as an overt act in the conspiracy. It says much more. The core immunity that the majority creates will insulate a considerably larger sphere of conduct than the narrow core of, quote, conclusive and preclusive end quote, powers that the court previously has recognized. The first indication comes when the majority includes the president's broad duty to, quote, take care that the laws be faithfully executed, end quote, among the core functions for which a former president supposedly enjoys absolute immunity. That expansive view of core power will effectively insulate all sorts of non-core conduct from criminal prosecution. Were there any question, consider how the majority applies its newly minted core immunity to the allegations in this case. It concludes that, quote, Trump is absolutely immune from prosecution for, end quote, any, quote, conduct involving his discussions with Justice Department officials, end quote. That conception of core immunity expands the, quote, conclusive and preclusive, end quote, category beyond recognition, foreclosing the possibility of prosecution for broad swaths of conduct. Under that view of core powers, even fabricating evidence and insisting the department use it in a criminal case could be covered. The majority's conception of, quote, core, unquote, immunity sweeps far more broadly than its logic. Borrowed from Youngstown, should allow. The majority tries to assuage any concerns about its made-up core immunity by suggesting that the government agrees with it. That suggestion will surprise the government. To say, as the government did, that a, quote, small core of exclusive official acts, end quote, such as, quote, the pardon power, the pardon to recognize foreign nations, the pardon to veto legislation, and the power to make appointments, end quote, cannot be regulated by Congress, does not suggest that the government agrees with immunizing any and all conduct conceivably related to the majority's broad array of supposedly, quote, core, unquote, powers. The government, in fact, advised this court to, quote, leave potentially more difficult questions, end quote, about the scope of any immunity, quote, that might arise on different facts for decision if they are ever presented, end quote. That would have made sense. The indictment here does not pose any threat of impermissibly criminalizing acts. We're going to start that again because I can't read. The indictment here does not pose any threat of impermissibly. Oh my gosh. Impermissibly. The indictment here does not pose any threat of impermissibly criminalizing acts within the president's, quote, conclusive and preclusive authority, end quote, authority. Perhaps for this reason, even Trump discouraged consideration of, quote, a narrower scope of immunity, end quote, claiming that such an immunity, quote, would be nearly impossible to fashion and would certainly involve impractical line drawing problems in every application, end quote. When forced to wade into thorny separation of power disputes, this court's usual practice is to, quote, confine the opinion only to the very questions necessary to the decision of the case, end quote. There is plenty of peril and little value in crafting a core immunity doctrine that Trump did not seek and that rightfully has no application to this case. Not content simply to invent an expansive criminal immunity for former presidents, the majority goes a dramatic and unprecedented step further. It says that acts for which the president is immune must be redacted from the narrative of even wholly private crimes committed while in office. They must play no role in proceedings regarding private criminal acts. Even though the majority's immunity analysis purports to leave unofficial acts open to prosecution, its draconian approach to official acts evidence deprives these prosecutions of any teeth. If the former president cannot be held criminally liable for his official acts, those acts should still be admissible to prove knowledge or intent in criminal prosecutions of unofficial acts. For instance, the majority struggles with classifying whether a president's speech in his capacity as president, official act, or as a candidate, unofficial act. Imagine a president states in an official speech that he intends to stop a political rival from passing legislation that he opposes, no matter what it takes to do so, official act. He then hires a private hitman to murder that political rival, unofficial act. Under the majority's rule, the murder indictment could include no allegation of the president's public admission of premeditated intent to support the mens rea of murder. This is a strange result, to say the least. Good God. I know we probably have it somewhere, but we're just going to take it down again. The majority's extraordinary rule has no basis in law. Consider the First Amendment context. Although the First Amendment prohibits criminalizing most speech, it, quote, does not prohibit the evidentiary use of speech, end quote, including its use, quote, to prove motive or intent, end quote. Evidentiary rulings and limiting instructions can ensure that evidence concerning official acts is, quote, considered only for the proper purpose for which it was admitted, end quote. Huddleston v. United States, 1988. The majority has no coherent explanation as to why these protections that are sufficient in every other context would be insufficient here. It simply asserts that it would be, quote, untenable, end quote, and would deprive immunity of its, quote, intended effect, end quote. The majority hazards an explanation that the use of official acts evidence will, quote, raise a unique risk that the jurors' deliberations will be prejudiced by their views of the president's policies and performance while in office, end quote. That, quote, unique risk, unquote, however, is not a product of introducing official acts evidence. It is simply the risk involved in any suit against a former president, including the private acts prosecutions the majority says it would allow. Today's decision to grant former presidents immunity for their official acts is deeply wrong. As troubling as this criminal immunity doctrine is in theory, the majority's application of the doctrine to the indictment in this case is perhaps even more troubling. In the hands of the majority, this new official acts immunity operates as a one-way ratchet. First, the majority declares all of the conduct involving the Justice Department and the Vice President to be official conduct, yet it refuses to designate any course of conduct alleged in the indictment as private, despite concessions from Trump's counsel. Trump's counsel conceded, for example, that the allegation that Trump, quote, turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results, end quote, quote, sounds private, end quote. He likewise conceded that the allegation that Trump, quote, conspired with another private attorney who caused the filing in court of a verification signed by Trump that contained false allegations to support a challenge, end quote, quote, sounds private, end quote. Reference in the case, Trump's counsel explaining that it is not, quote, disputed, end quote, that such conduct is, quote, unofficial, end quote. Again, when asked about allegations that, quote, 3 private actors helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and Trump and a co-conspirator attorney directed that effort, end quote, Trump's counsel conceded that the alleged conduct was, quote, private, end quote. Only the majority thinks that organizing fraudulent slates of electors might qualify as an official act of the president, or at least an act so, quote, interrelated, end quote, with other allegedly official acts that it might warrant some protection. If the majority's sweeping conception of official acts has any real limits, the majority is unwilling to reveal them in today's decision. I'm going to pop that down here. Moving on. Second, the majority designates certain conduct immune while refusing to recognize anything as prosecutable. It shields large swaths of conduct involving the Justice Department with immunity, but it does not give an inch in the other direction. The majority admits that the vice president's responsibility, quote, presiding over the Senate, end quote, is, quote, not an executive branch function, and it further admits, end quote, that the president, quote, plays no direct constitutional or statutory role, end quote, in the counting of electoral votes. Yet the majority refuses to conclude that Trump lacks immunity for his alleged attempts to, quote, enlist the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results, end quote. Instead, it worries that a prosecution for this conduct might make it harder for the president to use his vice president, quote, to advance his agenda in Congress, end quote. Such a prosecution, according to the majority, quote, may well hinder the president's ability to perform his constitutional functions, end quote. Whether a prosecution for this conduct warrants immunity should have been an easy question, but the majority turns it into a debatable one. Remarkably, the majority goes further and declines to deny immunity even for the allegations that Trump organized fraudulent slates of electors, pressured states to subvert legitimate election results, and exploited violence at the Capitol to influence the certification proceedings. It is not conceivable that a prosecution for these alleged efforts to overturn a presidential election, whether labeled official or unofficial under the majority's test, would pose any, quote, dangers of intrusion on the authority and functions of the executive branch, end quote, and the majority could have said as much. Instead, it perseverates, I don't know, never seen it before, on a threshold question that should be immaterial. Looking beyond the fate of this particular prosecution, the long-term consequences of today's decisions are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now, quote, lies about like a loaded weapon, end quote, for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune. Immune, immune, immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he might one day face liability for breaking the law, he might not act as bold. He might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. The majority's single-minded fixation on the president's need for boldness and dispatch ignores the countervailing need for accountability and restraint. The framers were not so single-minded. In the Federalist Papers, after, quote, endeavoring to show, end quote, that the executive designed by the Constitution, quote, combines all the requisites to energy, end quote, Alexander Hamilton asked a separate, equally important question. Quote, does it also combine the requisites to safety, in a Republican sense, a due dependence on the people, a due responsibility, end quote. The answer then was yes, based in part upon the presidency's vulnerability to, quote, prosecution in the common course of law, end quote. The answer after today is no. Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy,